Okay, we're live.
Big day.
Big day. It's finally come. Hi, Aaron. Very exciting news to finally have some official details on the program, but they have been released very close to on the day of when they'll start accepting applications.
Yeah, so a little background for everybody that this Parole in Place program for spouses of U.S. citizens and stepchildren of U.S. citizens was announced back in June, and they said that they would start accepting applications on August 19th. And we've been waiting and waiting and waiting for guidance about how this was going to look, and they released it on the morning of August 19th today. So we have a 94-page Federal Register notice and voluminous Q&A on the USCIS website, and we have been busily working through it and starting to prepare applications for clients who are already working on this. And so it's an exciting day because, as we've discussed on previous calls, this is going to open up the ability to adjust status for lots of people who otherwise were kind of stuck. So we're excited about it, but are still certainly wading through all the details on our end.
Yeah, there's a lot of information that, even though they have released a bunch of info, we're still processing it all, making sure that we understand it correctly. So apologies for not having it all in our heads after it was released earlier this morning, but we're working on it. What we can say for sure is that you have to apply online. They are not accepting paper filings for this form. It's called an I-131F. And because you're filing online, that means that you need to have a uscis.gov account. So if you do not have an account yet, you should set one up. And for our clients, you still can have an attorney working on it. So we'll help our clients prepare the forms. Then it'll be emailed over to them digitally. They can review it on their end, and then we're going to finalize it all together in some digital magic. So we know at least that much, and we also know the filing fee. Do you know the filing fee off your top of your head, Aaron?
It's $580. So the $580 is for the new form that they're using. It's called the I-131F. And then only after the I-131F is approved, then you can file for a work authorization document if you would like, based on the parole, which is a separate filing fee. And that one depends on whether that one can be filed, I believe, online or by mail. And so that is slightly different based on how it's filed. Some people will choose to file that work authorization application, and some may not because they might be doing it with their adjustment application. So the way that it works after the parole in place is filed and then approved is probably a little bit different depending on circumstances of each individual. But the initial filing, we know, is $580 that USCIS is going to charge.
Yep. Yeah. And outside of those details, again, like we already said, we're still working through the pages and pages and pages of additional information. There's questions still for me over whether people that were permanently barred are eligible for this program. I'm still not 100% sure on it because their answers are very vague, but it seems to me that they're leaning towards allowing people that are permanently barred to at least get paroled. But if you're paroled, that does not mean that you can then get a green card. So for folks in that situation, maybe you can possibly get parole if that's correct. They don't explicitly say so, but there's some hints in there that it's possible. But then you can get work authorization for 3 years, and then they have indicated too they're not intending to re-parole people at the end of this 3-year period. I've seen that in there. So for now, it seems like the benefit for people that are permanently barred is that they could get 3-year work authorization and parole, and then it would expire and you would go back to not having status, potentially. I mean, again, they're not clear. We still have a lot of information to process, but that's what it seems like to me.
Yeah, I agree. And so for for people who are subject to that permanent bar, there's actually two ways you can trigger it. One is by re-entering illegally after a deportation. Those people are not going to qualify at all. The ones that triggered the bar by accumulating over a year of unlawful presence and then leaving and then coming back illegally, I agree with Ryland, and Ryland's the one who actually spotted this little phrasing in the Q&A, and it seems to contemplate that they can be approved for this benefit. And so there's going to be an analysis that each person in this situation has to do about the risks of submitting your application and knowing that there's a chance it could be approved, but also there's a chance you could be denied and potentially put into removal proceedings. And also the limited benefit of, it's a 3-year max and it's not going to be renewable. Versus, some people just really have been waiting a long time and want to get some kind of protection and work authorization, even if they know it's temporary, and just want to do it. And so I think that there are obviously going to be different circumstances for every person, different risk tolerances, and it's going to be something that has to be thought through carefully. But it does appear to me, I agree with Ryland, that these people should qualify for the parole in place.
Yeah, and one additional note that I saw regarding if you're denied and whether then that might put you into removal proceedings, I saw in the FAQ that they say if they deny the applications, generally they will not be issuing a notice to appear in immigration court unless they deem you to be a threat to national security, public security, or border or immigration security. So generally they're saying they won't, but they still save themselves the ability to do so. So, but if you have a clean record and if you wouldn't be considered eligible or a priority for them under the current ICE guidance, I would think that they shouldn't issue you an NTA, but it's possible that they might anyways.
I would totally agree with that. I think that risk would probably be really low for a lot of people. The elephant in the room, though, is that DHS guidance for NTAs might change if there's a different administration. And so some of those answers really won't be known until at least November. And so that's another thing that people have to think through about whether those types of guidance might change.
Yeah, 100%. All right. Well, it looks like we don't have any questions. And again, we need to get back to kind of processing all this information so we can figure out what we're doing and how. But you have anything else you wanted to add, Aaron?
No, I'm just I'm excited that this is finally here, and the people who clearly benefit can or should clearly benefit can get their applications in, and we're hopeful that some of the earlier people might even get quick adjudications. Maybe that's overly hopeful, but we'll see.
Yeah. And we have no idea about processing times right now. That is all in USCIS's court. So unfortunately, we can't offer any predictions on that. But we would hope the earlier you submit, the earlier that you can file. And unfortunately, all of this information didn't come out weeks ago. It came out today, as we've repeatedly said. So we would like to get everybody filed as quickly as we can, but we still need to sort out the mess. Well, thank you, Aaron, for joining me on the stream. And we'll see you all later. Oh, one more thing is we're actually going to have another stream on Wednesday in Spanish about, and probably by that point we'll know more details and we can provide some more information. But so if you want to tune in on Wednesday, it's going to be Spanish language only, and then we're going to have additional streams that's keeping to our same schedule: Monday in English at noon, Wednesday in Spanish at noon. For more details as we are able to process it all and figure this all out. So see you then.
All right. Thanks all.
Thanks. Bye.